money off of it, you need to make sure that the place is reasonably safe.
Yeah.
Yeah. Any other thoughts on foreseeability?
The only other thing I wanted to share that just came to mind is it's also it's important to think about like what can we use to establish that what they did or didn't do was reasonable or unreasonable, right? Because like you were saying with self-service areas, maybe they did check it every hour, but right after the check someone spilled something and that's when it happened, right? So that does matter. What were they doing or not doing, and was that enough to prevent the hazard?
Yeah, and sometimes you need to get an expert involved to determine whether it's enough or not. Because, like in a retail store, there may be a particular standard, but like in a restaurant, it's a different standard.
Right.
So
Yeah.
getting and oftentimes we can look at the store's own policy manual to help us determine what's reasonable and what's not reasonable in terms of safety standards.
Yeah, but it's really important to think about that to make sure that we're putting forth enough evidence to get over that summary judgment standard. We can't just say, well, they didn't do checks every hour. What should they have done? And what evidence do we have that they should have done that?
Yeah. So from the case manager and the attorney who's handling these premises liability case, you know, gathering evidence early on is important. Sending out that preservation letter, that's important. Making sure that you get video and making sure you get pictures and getting a good description from the injured person, how it happened, and talking to the witnesses early. And if we can't get that, if we don't get liability accepted, which almost always it's a denial of liability, making sure that it gets up to the lit team, before the 9-month mark is kind of critical, because once the litigation team gets it, they can do discovery and they can get a lot of the information that we couldn't get in the pre-litigation stage. So getting it filed early on is also important. Oh, and making sure that the injured person filled out a claim form with the business or the property owner. That's a key piece of evidence there. We've had situations where it's just like, the like Targets, they say, well, we didn't even know somebody got injured there.
Right.
I mean, but a claim form protects against that defense.
Mm-hmm.
It,
And that's something we always want to ask about on intake too. For the intake folks watching this, we always want to ask about whether they filed a claim with the store, and if they didn't, we always recommend that they go back and do that ASAP,
yeah.
before it even gets to the pre-lit team.
Yeah. And then the other defense that we hear often, almost on every case, is open and obvious. And, the best example of that would be like a sidewalk case where, there's a raised area of the sidewalk because the two cement blocks kind of push up against each other, or there's a tree root growing underneath, which causes, a raised sidewalk, and somebody trips and falls on that, I mean, the one that you hear all the time, well, it was open, it was obvious. Anybody who was walking along here could see that it was a raised portion of the sidewalk, and therefore that's the defense.
Right. And you can think about the public policy context for that one too, right? Basically, in this case, we're saying people who get injured on dangerous conditions do have some responsibility to keep themselves safe from obvious dangers in their path, right? So
Yeah.
we're not going to hold the city responsible for every single little dip in a sidewalk if you can see it clearly, you should have just avoided it, right? If there's a way to get around it and it's obvious, and so again, you can think of the policy